25 CR 1199 is called the State of Texas versus Kimberly Vasquez.
Before we
That
even
is
get into
you.
the charges,
No.
understand
Your
this.
attorney, Mr.
What you're
Franklin,
about
and
to
the state's
see is a
attorney.
courtroom
Does the
moment where
defendant waive a
one
formal
bad
reading of this
decision
indictment
nearly
and arraignment?
turns
Can we
into a
proceed in summary?
life-altering
Yes,
felony.
Ron.
In
A high
summary,
school
this
incident,
indictment
a
alleges that
police
on or
officer
about April
and a young
29th,
defendant standing in
2025,
front
in
of a judge who
Jefferson
is
County,
clearly not
Texas,
impressed.
you committed the
What starts as
second-degree
a
felony of
second-degree
assault on a
felony,
peace officer.
carrying up to 20
It says
years,
by
slowly
scratching and
transforms into
kicking
something very different.
the
But not
officer
before tough
who knew he
questions,
was a police
uncomfortable
officer,
truths, and a
lawfully
serious
discharging
lesson
an
about
official duty.
accountability. Watch
What would you
closely
do?
because
Why
every
would you
answer
do
here
something like
matters,
that?
and the outcome hangs
That's
on
so
how this moment is
unladylike.
handled.
Let me read this. I'm interested in. Well, this is just plain dude. What's wrong with you? I'm asking you a question. What's wrong with you? Why would you? Why would you act this way? This is rude and abusive. It's illegal, but is that the way you are? No. Were you intoxicated?
No,
You weren't. This is the way you act. This is normal.
no, you're wrong.
Yeah, and this happens at the Beaumont Independent School District at Beaumont United High School.
Yes, sir.
Why were you there?
I was at school.
Oh, you're a student there?
You're not.
Is that right? You were a student.
Yes, you.
Okay. The police went in there to investigate you being disruptive, apparently, and you attempted to strike him. The middle of a hand, he grabbed your hand to avoid the strike. You began to scratch his left hand. At this time, you were told you would be detained. You then struck him with your right foot. A police officer. What would you do to a regular person that you had a quarrel with if you're going to do this to a police officer? Was he wearing a uniform and everything?
Yes.
Yes. Is that the way you normally deal with police officers? By striking them and scratching them? No. What is your grade
This
level?
is where
You're
the
a senior
courtroom
or
tension
something?
really
Yes.
peaks.
Did you graduate?
Notice how the judge
I'm
isn't
almost
just reciting
done with
facts.
school.
He's
I
probing
got into
intent,
the GED
maturity,
program,
and self-control.
5.
Assaulting a peace officer isn't treated lightly,
Have you ever been in
especially when
trouble
it happens on a
before?
school campus.
Criminal trouble?
The judge is
No,
clearly
no.
trying to understand
Do you
whether
fight
this was a
regularly with
one-time
people?
emotional breakdown
What
or a
happened?
pattern of
What was
behavior.
this all about?
And that distinction matters a
You
lot.
You don't know.
Courts don't just punish
Yes.
actions, they assess risk.
I don't
Is
know.
this defendant
But
someone who
that's
made
your
a
answer? You
terrible
don't
decision
know?
under stress?
You
Or
know.
someone who
What
might
was it?
repeat it? The
Did
lack of a
something bad
clear
happen that
explanation,
day to
I
you or
don't
something?
know, doesn't
That
help her
that
here. Viewers,
made you
ask
angry or
ourselves,
something?
There was a
if you
fight
were in the
right
judge's
before this,
seat,
Your Honor, between
would
them.
that
Yeah,
answer
I see.
reassure you,
I was
or worry
trying to
you
get
even
from
more?
Yes, sir.
Well, kids.
Were you in some kind of a disagreement,
No,
a fight or something?
no. I was just waiting to go home and.
And for no particular reason, you strike a police officer while you're waiting to go home. There's something stirred this up and provoked you, right?
Him getting in my face was provoking.
Oh, well, police officers, I'm sure they just didn't do it just to enjoy it. I'm sure they did it because they were responding to some call, because that's what this states is I received a call via school radio for assistance in the administration building. I observed a Hispanic female, you, argumentative in nature and not following the directives by the administrator. So before he got there, you were apparently arguing with the school staff. And then as he approached you, you began to tell him in an aggressive tone that he was not to speak to you. Okay. Do you understand you're not the boss? I mean, when it comes to dealing with
Yes.
disturbances, the officials have to handle. Okay. Well, you know what you've been through. You don't want to do this again, right? Okay. Oh. Okay.
I did speak with the complainant, Your Honor, and it was his wishes that The defendant did not receive a felony conviction. Yeah.
Yeah, you are looking at here, a second degree felony as it's indicted. This means if convicted, you would be looking at no less than no more than 20 years confinement in prison. And a fine up to $10,000 could be assessed. Do you understand the punishment range for what you were indicted with? So what the parties, your attorney and the state have done is agreed that this indictment would be prosecuted as a lesser included offense of a Class A misdemeanor, which carries with it, nobody wrote this down, but you need to on this, up to 1 year in the county jail and or a fine up to $4,000. It's not on here. Do you understand what you're facing here? And that this Class A misdemeanor would be disposed of by placing you on deferred or unadjudicated probation so that you would not be convicted of this crime so long as you follow the terms and conditions of probation that can be up to 2 years in length. Do you understand? If I follow this agreement, you have no right of appeal of your case. Do you understand that? How do you plead to the lesser included Class A misdemeanor of assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign a document, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection, it is. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you or you've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Your Honor.
All right, I'm going to find as follows, ma'am, that you are pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to give you a second chance on this. I'm going to place you on deferred or unadjudicated probation, which means you will not be found guilty so long as you follow these terms and conditions of probation. Fix this. There will be terms and conditions of probation that all of us, actually, most of which are all of us have to follow anyway, when we're not even on probation. They're just regular things of live honestly, harm no one, give each person respect. And there is no restitution here, I guess.
No, Your Honor.
Okay, there's no either. Fine. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked, and then you could be found guilty and sentenced up to 1 year in the county jail, which you don't want. One of the terms and conditions of probation, we're going to order you to complete is an anger management program. That's a good thing. Helps you think about controlling your emotions before you're about to make an important decision that could affect your life. All right. Do you understand what's happened today?
Yes, sir.
Okay. You're not a regular person who fights and loses control, do you? Oh, well, then fix it. Don't do that. You see, you don't need to go through all of this. This is stuff that I think you're more worthy than this. You need to be in a better environment where you're getting educated, working, and taking care of a family and things like that. This will work out. Follow the rules and follow the probation office. Okay. Thank you very much.
Thanks. Excuse?
How long is the probation?
It's 2 years.
2 years. Thank you, Judge.
Yes, sir. Thank you.
In the end, this case is a textbook example of how close someone can come to ruining their future and how judicial discretion can change everything. The defendant was originally facing a second-degree felony with a potential 20-year sentence. Instead, The court accepted a plea to a lesser class, a misdemeanor, and granted deferred adjudication. That means no conviction, as long as probation terms are followed. This judge balanced accountability with rehabilitation, ordering anger management, and stressing personal responsibility rather than pure punishment. But make no mistake, this was a second chance, not a free pass. One violation, and the consequences come rushing back. So what do you think? Was the judge fair, too lenient, or exactly right? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.